Hey everyone, welcome back to my channel where we bring you current legal news. In this video, we're going to be looking at a recent Ontario Court of Justice decision in a case called Toronto v. Lee Tucker, 2025 ONCJ 323. The facts surrounding this case are pretty straightforward. The defendants, Henry Schein Canada and Lisa Lee Tucker, have a commonality, which is why the appeals were heard together. Both were charged with offenses under Part 1 of the Provincial Offences Act RSOC, P33, as amended. Both appeared at an early resolution meeting after requesting one, and in each case, His Worship stayed the proceedings against them because of both a violation of the respondents' rights under Section 11 of the Charter and also because of a common law abuse of process. The City of Toronto appeals both decisions. In each case, the respondent was served with the appeal materials but did not appear. For the following reasons, both appeals are allowed and the stay is vacated. Let's dive right into the reasons. At the outset, Judge David Rose states that trial judges must remain impartial and neutral to each side for risk of entering the fray. What happened here is that the presiding justice of the peace went a step too far. In each of these cases, the respondents were charged with relatively minor offenses, each carrying a fine of $110. Each respondent requested and was granted an early resolution meeting. At the conclusion of the early resolution meeting in each case, the justice stayed the proceedings. A stay of proceedings is a type of remedy which is discretionary in the court and is essentially a way of having the charges against you completely dismissed. In this case, the justice exercised his discretion and granted the stay due to two reasons. In reaching his decision, the justice made some rather controversial comments. He stated that the court has inherent power to control its own processes, and that includes quashing proceedings that are unfair or oppressive, even if they are not pursuant to a statutory power. He goes on to say that courts have the inherent power to ensure that public resources are used judiciously and not wasted on prosecutions that are demonstrably hopeless. Now, while it is true that courts have the inherent power to control their own processes, and that includes the power to stay proceedings, this power is rarely, if ever, used in this type of situation. As stated in the case of R.V., Morin, a stay of proceedings is not a substitute for an acquittal or conviction. In my view, the comments made by the justice in this case are concerning to say the least. It appears as though he is giving reasons based his personal views of what is fair and reasonable rather than what the law is. The language used is such that if you are a citizen, you may feel as though judges are making up the rules as they go along. This type of language and reasoning could undermine public confidence in the administration of justice. Having said that, in this case, the appeal was allowed and the stay was vacated. If you have any questions, please feel free to reach out. I would like to thank you for watching and ask that you please like and subscribe.